Assalamu alaikum wa rahmatullahi wa barakatuh. Ahlan wa sahlan. Welcome to this video, guys. My name is Liaquat. Hope you guys are having a fantastic day. This series is Mukhtasar al-Qudoori, helping you guys to understand Hanafi Fiqh. If you guys like my videos, you like the channel, you like me, then hit the like button, hit the subscribe button, share my videos, and also leave a comment as well. Right, so let's crack on with this then. So, وَإِذَا اشْتَرَطَ عَلَى الصَّانِعِ. So, اشْتَرَطَ, it means to condition. Okay, so a lot of these words, again, you are going to know these words, so I'm not going to go through each one. Sani, it means craftsman. Ya'malu, to work. Yasta'milu, to utilize, use. Yasta'jiru, to hire. Ikhtalafa, differ. Ikhtalafa, yakhtalifu, ikhtilaf. Khayyat, you come across this before, tailor. And then qamis is a shirt. Sabbagh is someone who dyes cloth. Yeah, so it dyes cloth. And then you've got tusbiru. So to dye it. Asbagha yusbiru isbagh. Or tasbaghu. Sabagtahu asfar. Asfar is yellow. And then halafa yahlifu, to swear an oath. Khayyat, again, so oath. And then you have damin, is responsible. This person responsible. Amiltahu, amila ya'malu. Ujra is fee, payment. And then qala as-sani' la budda. You can see a lot of these words, they've already been done anyway. So I'm not going to keep going over these. So ujra is fee, thob is cloth, yameen is oath. Again, kana harifan, skilled. Ujra, lam yakun harifan. Ujra, fee. Sani is craftsman. Ma'ruf is known. Arafa ya'rifu. Arif, ma'ruf. San'a, it means type of work. Ya'mal bil ujrati. Ujra, ijara. Fasida, ajr mithl la yatajawaz, to go beyond. And then musamma is known or stipulated. Yeah, rather let's put stipulated. Stipulated. Alright, so that's basically the words that you've got over here. Now let's have a look at the tarkeeb of this. Now, note, by the way, this is second to last lesson of ijara. Okay, the next lesson is going to be the last lesson of ijara. Then we're going to start shufa. So those of you guys who are dying for shufa. So we're going to start shufa, inshallah, after that. So, إذا اشترط is fi'l plus the fa'il. على الصانع أن يعمل بنفسه جار مجرور. ليس له أن يستعمل غيره مفعول به. فإن أطلق له العمل, this is the مفعول به of أطلق. فله أن يستأجر من يعمله. وإذا اختلف الخياط وصاحب الثوب. فاعل فقال صاحب الثوب مضاف إليه فاعل أمرتك أن تعمله قباء وقال الخياط قميصا. Alright, so this is going to be مفعول به of a hidden verb, okay? So there's a hidden verb over here. أو قال صاحب الثوب للصباغ أمرتك أن تصبغه أحمر. This is غير منصرف, ممنوع من الصرف. فصبغته أصفر, again same thing as أحمر. فالقول مبتدأ. قول صاحب الثوب مع يمينه. فإن حلف فالخياط is the مبتدأ. ضامن خبر. Now by this time I think you guys are very familiar with this i'rab and tarkeeb, and I think. What do you guys say? Am I right? وإذا قال صاحب الثوب عملته لي بغير أجرة وقال الصانع لا بل بأجرة. فالقول مبتدأ. قول صاحب الثوب مع يمينه عند أبي حنيفة. وقال أبو يوسف إن كان حريفا, خبر of كان. إن كان حريفا له فله الأجرة, مبتدأ مؤخر. وإن لم يكن حريفا, خبر فلا أجرة له. وقال محمد إن كان الصانع معروفا بهذه صنعة أن يعمل بالأجرة فالقول مبتدأ قوله خبر أنه عمله بأجرة والواجب في الإجارة الفاسدة أجر المثل لا يتجاوز في الفاعل به المسمى. Right, that's just manqus. Alright, so that's basically the i'rab part you got there. Now let's have a look at explaining the masail now. So this is the part which is the juicy part of the lesson, inshallah. Right, so here this whole section is basically to do with how do we deal with like particulars in the contract, right? Details in the contract. So a lot of trade is to do with details in the contract. So for example, let's say this guy, he goes to, let's say for example, this worker. So this guy is the tailor, for example, right? So say tailor, and this guy, he basically says to him, you have to make for me my clothes. You have to make it. Right? So he stipulated in the contract that I want you to make it. Because technically, if this guy does not say this, the tailor is allowed to give it to someone else, like one of his workers, or outsource it to get it done by them. So remember that, okay? So if you're ever given something to make and the person hasn't stipulated for you to make it, then it's permissible for you to hand it over to someone else. However, because he has stipulated that he makes it, then he obviously has to make it. So that's why over here it says, وَإِذَا اشْتَرَطَ, if this guy, the client, the customer, he stipulates عَلَى الصَّانِعِ, upon the craftsman, أَنْ يَعْمَلَ بِنَفْسِهِ, that he has to do it yourself or himself. فَلَيْسَ لَهُ, then he, the tailor, does not have the right أَنْ يَسْتَعْمِلَ غَيْرَهُ, to utilize the work of someone else. Right? So he can't get one of his apprentices or his other colleagues to do it for him. Okay, he's got to do it himself basically. Okay, however, if he was to leave it open, right? So if he just left it open, for example, he just said, just get me this done, open contract, then obviously he can do it, or he can get one of his workers to do it. Right, so his workers can do it, and then it's also considered to be fine as well. فَإِنْ أَطْلَقَ له الْعَمَلَ, so if he was to leave the action open to him, the work open to him, right? So he أطلق open. فَلَهُ, so the tailor now has a right أن يستأجر من يعمله, he can actually outsource it, give it to someone else to get done. This is what happens sometimes when you go to a garage. You give your car to them to get fixed, and then they might not be able to do it themselves, so they get someone else, pay someone else to get it done for them. Right? So a lot of companies will actually do this. So you pay them, and then they pay someone else. So this is also permissible as well. Okay, right. Next. Now, the next issue is that what if there is a dispute between the two individuals, right? Because this can happen a lot in trade, in business. So you have to be aware of this. So for example, this guy, he has told the tailor, for example, so let's call him Mr. T. Mr. T and the client, Mr. C. So he's done some work for him, right? So this tailor, he's done some work for him. Let's say, I don't know, he's made, let's say, for example, let's do it in a different color. Right, so he's made, I don't know, some sort of a attire for him, right? Look at that. Look how slick that looks. Eid clothes. Eid clothes, guys. So he's basically looked at it and he said, wait a minute, I told you to make me a coat. And he's saying, no, you didn't. You said to make me a shirt and trousers, for example. Yeah, so one of them is saying coat and the other one is shirt. Basically, there is a dispute of what was mentioned. Yeah, what did the guy say make? Yeah, so this could be one. Or for example, like it could be a situation where the guy gave cloth and then he said to him, you know what? So he's basically, so let's say he's made the clothes yellow. He's put yellow dye on there. And this guy is like fuming. He's saying, I told you make it red. and you have made it yellow, right? So he's saying, no, you said yellow. So either the dispute is what design it was supposed to be, and or dispute is color, or anything like that. Yeah, you could take your car to the garage, and you might say to them, look, I told you to paint the car silver, and you painted it white, right? So this is a difference. Or for example, I don't know, I told you to put these tires on, not those tires on. So there's a dispute between the customer and between the seller. In this case, what is going to happen over here? So he says, إذا اختلف الخياط. So when the tailor differs with صاحب الثوب, the guy who owns the thobe. فقال صاحب الثوب, the guy who owns the thobe said, أمرتك أن تعمله قباء. I specifically told you to make it into a coat. وقال الخياط قميصا. No, you said a shirt. In this case, shirt and trousers. أو قال صاحب الثوب للصباغ. Or صاحب الثوب said to the guy who's the dyer. I don't know, do you call it dyer? Let me know. أمرتك أن تصبغه أحمر. I told you to dye it red. فصبغته أصفر. You actually made it أصفر. Yeah, you guys, you made this yellow. Now, in this case, what's going to happen? They're going to go court, basically, right? So in the books of fiqh, they don't actually mention the court, but you have to know this. So what's going to happen? This dispute now is going to be raised. It's going to go to the judge. So Judge Saab, right? He's going to look at the case, and basically, so let's just put judge over here. Now he's going to follow this protocol. What's the protocol? The protocol is this. So the claimant, the guy who is making the claim, he has to provide proof. And the defendant, the guy who is defending, yeah, he does not have to provide proof. No proof needed. Now, if there is no proof, so let's say, for example, there is no proof. So if there is proof, he wins the case. Right? Case one. This guy won the case. But if there is no proof, then what happens in this case? Then it will go to oath. So the defendant will swear an oath. All right, then he wins the case. And if he refuses to swear an oath, he refuses, then by default the other guy wins the case. So if he refuses, then he wins the case. So now we have to figure out who is the claimant here. This is the whole issue now. Who in this case, who is a claimant, who's making a claim, and who's defending? Right? So the rule for identifying the claimant or the defendant is that the defendant is upon the norm. So who in this case is on the norm, right? So who is on the norm, and who in this case is going against the norm? Because the guy going against the norm, he has to provide proof. That's how the rule works, right? So the guy going against them. Now, if this guy is a customer and this guy is the tailor, who normally is right? That's the way to understand it. So the norm would be him, isn't it? He would be considered to be on the norm. And this guy would be against the norm. Like they say, the customer is always right. Because if the customer said, I asked for a coat, that means the default is that he should be correct. The other guy is going against the norm. If he is disagreeing with, that means that he has to provide proof. So that's why he's going to be the claimant, right? So if we now look at this, claimant is this guy, all right? He's the claimant, and the claimant has to provide proof. Do you have proof? Do you have a witness? Do you have a receipt or anything like that? Yes, no. If you do, then you win the case. He's won automatically, right? If he doesn't, so let's change the color of this. Let's make it red. This is the defendant. The defendant is not going to be asked for proof, and even if he's got proof, it won't be taken in court. All right, so the judge will not take it. Okay, then what happens if, this is scenario number 1. All right, let's put this there, number 1. If there is no proof, so this guy's got no proof at all, right? So then what's going to happen? So in that case, no proof, right? He's got no proof. He goes, I don't have any proof that you said make a coat or you said make a shirt. So then the judge is going to ask this guy, okay, the other guy on the other side, he's going to say to him, right, you swear an oath, say, Wallahi, I swear by Allah that I told you to make a coat for me. Right? And then if he says that, he wins the case. But in scenario number 3, if he refuses to swear an oath, so I don't want to swear an oath. Now that's a bit dodgy, isn't it? That's a bit suspicious. Why are you not swearing an oath? So because he's not swearing an oath, then by default, the other guy's going to win the case. Right? So this is where we have to understand that by refusing, the other guy wins the case. Right? This guy's going to win the case. Everyone understand this? Play it back. Listen to it again, inshallah. So let's go back to this then. So now, if you look out here, it says, in these two cases where the dispute takes place, al-qawlu qawlu sahib al-thawb ma'a yaminihi. The statement that will be taken, because he is on the norm, what's going to happen is his statement will be taken. So this is what it means, al-qawlu qawluhu. His statement is going to be taken with an oath. So whenever in the books it says al-qawlu qawluhu, the statement is going to be his. The statement is going to be the statement of sahib al-thawb ma'a yaminihi, with his oath. That means this is after the proof has not been found. In other words, this is stage 2, okay? Remember this, right? So this is stage 2, because a lot of people get a bit confused on this. If obviously stage 1 has been achieved, then there's no need to go to stage 2. Make sense? So you have to understand, in the books of fiqh, there are hidden statements that they expect you to know, right? So this is what the hidden statement here is, meaning hidden statement would be, if the claimant, the tailor, does not have proof, then the qawl is going to be the qawl of the, right? So you would actually put this statement into here, yeah. So if I was to write it in there, I would say the burden of proof is on the tailor. Otherwise, فَالْقَوْلُ قَوْلُ صَاحِبٍ. Make sense? All right, so this comes quite a lot in the books, and a lot of students get confused with this. So, alhamdulillah, by now, you guys should understand what's happening over here. All right. So, this is now continuing from this masala then. So he says, فَإِنْ حَلَفَ فَالْخَيَّاتُ ضَامِنٌ. All right. So now, if he does swear an oath, because remember, that was his right. So if you go back up, actually, just go back up a bit there. Right. So now this guy has sworn an oath. So we've gone to stage 2. He's sworn an oath. So what's going to happen is, if there's any damages, obviously the cloth cannot be reversed, what he's done to it. So in that case, the seller will actually have to compensate him, buy a cloth for him. The cloth that he gave, he'll have to buy it for him. Right, so that's his fault. So فَإِنْ حَلَفَ, if this guy was to swear an oath, فَالْخَيَّاتُ ضَامِنٌ, the khayyat now is going to be damin, right? So he's the guy that's going to have to pay for this now. Compensation. Right, compensation. All right, next. Now, this is a bit of a strange masala, okay? So it's a bit of a strange masala. So let's say, for instance, there's this customer. And let's say, for example, there is this tailor, right? Customer, for some reason, customer says, you said to me you're going to do it free for me. Free of charge. And the tailor says, wait a minute. No, I said you have to pay. I didn't say it's free of charge. So does that make sense? So here you have the issue now is, how do you deal with the situation where you've got two people that are differing on whether there was a payment necessitated or not? So if you go to a shop and you say to them, you said you're going to fix my computer for free, or the garage, you said you're going to fix my car for free. What happens in this situation? When they go to court, the judge, right? So remember, they're going to go to judge again. Mr. Judge, so let's put the Mr. Judge in the middle. Okay, so he's Mr. Judge Saab. All right, so they're going to judge. Let's call him J. Mr. J. They're going to judge. So what's going to happen? So he says, إِذَا قَالَ صَاحِبُ الثَّوْبِ. So when the Sahib al-Thawb says, عَمِلْتَهُ لِي بِغَيْرِ أُجْرَةٍ. You said you're going to do it for free. You did it for me بِغَيْرِ أُجْرَةٍ, without a fee. وَقَالَ الصَّانِ, the craftsman, in this case the tailor, right? He says, لَا بَلْ بِأُجْرَةٍ. No, it was actually with a fee. So in this case, what exactly is going to happen? This is where Imam Abu Hanifa, so let's put AH here, and Imam Abu Yusuf and Imam Muhammad, they differ on this particular masala. Yeah, how are they going to deal with this? So Imam Abu Hanifa rahimahullah, he basically says this. He says that as before, remember we said previously, al-qawlu qawlu sahib al-thawb, right? So he is the defendant. So his statement plus oath, he makes that. This is obviously if there's no proof on the other side. So Imam Hanifa says the other guy has to provide proof. If there is no proof, then obviously the other guy wins, right? So, but this is what he says. Okay, what does Imam Abu Yusuf rahimahullah says? Imam Abu Yusuf, he's a bit different. He says that if this guy is a skilled worker, like this is his job profession, right? If he is profession, then he gets paid. Yeah, so he gets paid. Okay? And if it's not his profession, if he's just like some cowboy kind of guy, and normally you don't really kind of pay a cowboy guy. Like you go to someone, your friend or someone or some guy, my tire's burst, can you help me take it off? And they help you take the tire off the wheel, right? They don't really charge you for it. So he's saying if he's a skilled guy that's got a job, he's got a shop that does these things, you expect the norm would be that this guy gets paid. So he should get paid, right? And Imam Muhammad rahimahullah on the other hand, he says, if this guy is known for taking payments, if he's known for fees, right, then he gets paid. Yeah. So he actually will be, his statement will be taken with an oath, right? Unless the other guy has proof. Does that make sense? So this is the three positions. Let me say the three positions again. Imam Abu Hanifa rahimahullah, he says that as before, the statement and the oath is going to be upon the customer. Imam Abu Yusuf says, no, you look at whether he's skilled or not. If he's a skilled worker in this particular trade, like he's got qualifications in this, then you pay him. And if he's not skilled, then he doesn't pay. And that's Imam Abu Yusuf's position. And then Imam Muhammad's position, he says that if this guy is known in the community for actually taking a fee for this kind of job, then his statement is taken with an oath. And then he wins the case if the other guy does not have proof. Khalas. Right, so let's have a breakdown of this. So he says, so if this happens, وقال الصانع لا بل بأجرة فالقول قول صاحب الثوب مع يمينه عند أبي حنيفة. The statement that will be taken is the statement of صاحب الثوب, this guy, with his oath, like we said over here. وقال أبو يوسف, Imam Abu Yusuf rahimullah, he says, إن كان حريفا, if he is skilled, له فله الأجرة, then he gets the fee. وإن لم يكن, and if he's not skilled, حريفا, له فلا أجرة له, then there's no payment for him. Yeah, straightforward. And Imam Muhammad says, وقال محمد إن كان الصانع معروفا, if the craftsman, he is someone that is well known بهذه الصنعة, with this particular job in the community, whether he's skilled or not, but everyone knows him for that. Yeah, and he's known for taking a fee. And يعمل بالأجرة, that he takes this kind of jobs on for a fee. So he gets, for example, like someone who's a roofer, fixes roofs, or someone who's a gardener, and people know this guy normally takes a fee, £20, £30, £40, whatever it is. Then فالقول قوله أنه عمله بإجرة, then his statement will be taken, and obviously if his qawl is taken, then his oath is also taken as well. That's it. So that's basically if the dispute is regarding whether there was payment or not. And I see this difference here. This is a very important to understand how the courts deal with these kind of cases of disputes, right? So there is this general rule I told you above, which was the proof of burden is upon the claimant, right? And the oath is upon the other. Okay, finally, last masala, right? Last masala, and then we have finished, alhamdulillah. All right, so the last masala is this, is that just like you can have, remember we did buyu, right? So let's say, for example, this is a customer and this is a tailor, and let's say, for example, they did an agreement of ijara, but there was a shart in there that rendered the ijara fasid. Okay, so you can have an ijara fasid as well. So the ijara is now fasid. So if it's fasid, what is going to happen? What's the consequences of this? So this guy has made, for example, let's say, I don't know, some clothes for this guy, but it turns out that the ijara they did, the agreements they did, contained some sort of like a clause that was against Sharia, something like that. Then what's going to happen? So this guy actually to put all the effort into this. So if the agreement was, for example, that he was going to give him, let's say, £50 to do this, but it was an ijara fasida, what happens? He doesn't get £50. What he'll get, the courts will decide, and they'll give him what is known as the ujratul mithl, right? So ujra al-mithl, which is the normal fee that is in the markets. So in the markets, how much would people normally get paid for making something like this? So if you went on, let's say, I don't know, on the internet and you kind of Googled it and you found, oh, normally people pay a certain amount. So he gets that, whatever that is, so long as it does not go beyond £50. So as long as it's less than £50, less than £50. So whatever's in the market, less than. If it's above £50, then he only takes £50. Does that make sense? So if it's 20 or 30 or 40, then it's fine. But if it's £80, and normally the markets charge for this, then you don't take 80, then you go to the original 50. All right, so if it's an ijara fasida, he doesn't get the payment that was stipulated, but what he gets ujratul mithl, right? He gets the market value of that particular job. Yeah, and it can't go beyond the amount stipulated in the original contract. And that's it, guys. So let's have a look at this then. So he says, wal-wajibu, and the obligation fi al-ijara al-fasida is ajrul mithl, is the payment which is the similar payment, they call it, the payment in the markets. La yatajawazu bihi al-musamma. It does not go beyond the amount stipulated. That's the musamma. So this amount cannot go beyond, and obviously this 81 cannot go beyond £50. And if it does, then he just gets £50. Yeah. Khalas. Okay, let's have a check out. Questions for you guys now. You ready? Yeah? Okay. If a tailor or a customer stipulates if the customer stipulates in the contract that this particular tailor has to make his clothes, what happens? Can he outsource it to someone else? The answer is no. He must do it himself. Okay. Number 2. If he was to not stipulate that you have to make it, can he source it out to someone else? Yes, he can. Khalas. Okay, next question. If a customer and the tailor, they dispute regarding what was exactly told to be made. So the customer is saying, I told you to make a coat. Tailor is saying, I told you, you said to me to make a shirt and trousers. And they dispute on this. What's going to happen? And likewise, if the dispute is about the color as well. So the rule is this. What is the rule? You tell me. Okay, the rule is this. There's 3 stages of this. The claimant has to provide the proof and the defendant does not provide proof. If he provides proof, he wins the case. If he does not provide proof, then stage 2 is the defendant will swear an oath. And if he refuses to swear an oath, then the claimant wins the case. Okay, in this case, who is the claimant? So we look at who's on the norm. We find that the customer is on the norm. So therefore, his statement will be taken with oath after an attempt has been made to provide proof by the other party. All right. And if he doesn't swear an oath, then obviously the other party wins the case. Yeah, so this is straightforward there. Okay, next. What if 2 people, they dispute regarding fee, right? Whether the fee is a fee or not. So the customer saying, you said free of charge. Tailor saying, no, there was a fee. Then what's going to happen? Well, the judge is going to actually look into this. Abu Hanifa, Abu Yusuf, Muhammad differ on this. Abu Hanifa says you go back to the original one, right? The customer is always right. And Abu Yusuf says, no, you look at whether he's skilled or not. If he's skilled, he deserves a fee. If he's not skilled, then no. He's a cowboy. And Imam Muhammad says, is he known in the community for doing this job for a fee? If yes, if he is known for doing this particular fee, then he gets his statement and his oath will be taken. Right? Otherwise, the proof of the other guy will win. And finally, if a person was to do a ijara fasida with someone, then what happens? So the rule is they don't get the original fee, they get the ujratul mithl, so long as it's not more than £50, or the amount stipulated. Khalas. Everyone understand this? Everyone happy? MashaAllah. Jazakumullah khair, guys, for watching this. I hope you guys enjoyed this. Let me know what you use the videos for. Like, do you guys use them to teach? Do you guys use them to supplement your studies? Or is it you're just studying this on your own, as in you're not studying fiqh anywhere else? This is the only source that you're using. Let me know in the comments, inshallah. And thank you very much for watching the video, guys. It means a lot to me when you give me comments and likes and all that kind of stuff. I like that kind of stuff. And thank you to all my patrons for monthly supporting my channel. Honestly, it means a lot. I know, subhanAllah, you guys, out of the love of your hearts, you guys support my channel. May Allah bless all of you guys. If any of you guys want to support my channel as well, you want it on a monthly basis, consider it. It means a lot to me, helps my channel grow. And I will see you guys next time. Details in the description below. Assalamu alaikum wa rahmatullahi wa barakatuh.